And it didn't satisfy this part of the test, according to the majority, basically for two reasons. One, according to the majority, you couldn't fairly trace the inability to have integrated schools in the communities to these tax exemptions, or the IRS failure to deny these tax exemptions. Because the court said even if the tax exemptions were withdrawn, let's say the IRS was doing a great job, a great monitoring, and it withdrew all tax exemptions from any of these schools that discriminated, these private schools, it was hardly clear, the court said, and in fact speculative, the court said, whether the withdrawal of those exemptions would lead white parents to put their kids back in public school. It might very well be that if it was more expensive to go, they would still go. Maybe they'd have to pay more money, so what? And the schools themselves were unlikely to change their policies. So, the majority said, you can't show that even if you got the IRS to have a better monitoring program, even if you got the IRS to withdraw more tax exemptions from certain of these schools, you can't show that there was a substantial likelihood that that would result in the integrated system you're seeking. Now, the second part of Justice O'Connor's opinion, and the far more controversial part, is that Justice O'Connor said that the court would be especially reluctant to confer standing where it was worried about the propriety of allowing plaintiffs to go into federal court and basically sue to make the government do a better job, where the essential complaint of the plaintiffs was that the government wasn't effectively carrying out its obligation. The court, through Justice O'Connor, said that such a claim raised serious separation of powers concerns. And it raised serious separation of powers concerns because basically it would set the court up to be a monitor over how the executive branch was carrying out its duties to determine how well it was doing it. And this the majority was reluctant to do. Now, there was a dissent in Allen v. Wright written by Justice Stevens. The dissenter said, first of all, that the causal nexus is satisfied. Anybody knows that a tax subsidy, an economic advantage, affects what people do. And while we don't know that you'll have perfectly integrated schools if we withdraw tax exemptions from these private schools, it's fairly clear that there's a connection here between the withdrawal of tax exemptions and how people behave. So there is a sufficient causal nexus. Justice Stevens went further. He said that it was inappropriate for the court to raise separation of powers principles as part of the standing doctrine. If there were concerns about judicial interference with how the executive exercises its discretion, how it runs its programs, well, it's appropriate to raise that, he said, but not part of standing. It has nothing to do with standing, according to the dissenters. So, rules about standing, as I said, general standing, you need injury in fact and satisfaction of the causal nexus. Injury in fact can be pretty easy to see or argue about, but the causal nexus obviously is going to be harder because it lacks precision. And in fact, many commentators have noted how the requirement can be manipulated depending upon whether justices have sympathy for the underlying claim or not. What I suggest you do is, and it's undoubtedly the case that somewhere along the way, tucked into some question, will be a standing issue. What I suggest you do is look closely at who's bringing the suit. First, state the rules of standing: injury in fact, satisfaction of the causal nexus. Identify the injury in fact from the facts. Then ask yourself the second question: is the injury fairly traceable to the defendant's actions? And if the plaintiffs get what they're seeking, will it take care of the problem? And to do this, to answer that question in your exam, simply play a little bit of mental ping pong with the facts and see how that question would be answered in your circumstances. That, I think, is pretty much the best way to go about addressing standing issues.